and a very warm welcome to the second weekly seminar in what is currently phase 4 of the International Interdisciplinary PhD in Progress seminar series organised by the Global South Network. This phase will run through the whole year, so please do encourage anyone else who might be interested to join and participate. And I would also like to acknowledge and thank the organiser of the session, who's Dr. Norman Rayat from Leicester Law School, who also founded and convenes the Global South Network. My name's Rhona Smith and I'm Professor of International Human Rights at the Law School in Newcastle University in the UK. Although I've worked in various universities, both in the UK and also in overseas, particularly in Asia. So I spent quite a lot of my career working in human rights capacity building there. For the session today, I am joined by 3 discussants. We have 2 academic discussants and 1 peer commentator to look at Lornah's presentation. So you've got no pressure, a lot of people listening and commenting on what you're going to be saying. So I'm joined by our first discussant is Dr. Joycelin Eze-Okubuiro, who is a lecturer in law at Leicester Law School in the UK, and her research focuses in the field of public international law particularly, and they've been in Leicester Law School since 2022. Joycelin previously held academic positions both in Nigeria as a senior lecturer at the University of Nigeria and also in the UK as an associate lecturer at the University of the West of England. She's also qualified as a barrister and a solicitor in the Supreme Court of Nigeria, and in the UK at the moment teaches the law of tort and equity and trust, as well as international law and the use of force. Quite a range to cover. Our second discussant we're fortunate enough to have today is Dr. Arinze Okichi, who's a lecturer in law also at Leicester Law School. We have a predominance of Leicester Law School discussants today, and specialises in the African international economic law, broadly construed, with a particular emphasis really on international trade law and competition law aspects of that. His recent publication examines African practice in international economic law, and at the moment he teaches, again, quite a broad range, contract, constitutional and administrative law and international competition law. We also have a peer commentator that we're delighted is able to join us, who's Izioma Ewelukla. Sorry, I pronounced that wrong again. Ewelukla, sorry, is a peer, and that's our peer commentator for today. She's a PhD candidate also in Leicester at the law school there, and her PhD thesis involves a discussion on the African Union. So we have 3 very well qualified commentators joining us to look at our guest speakers presentation today. And our guest speaker that we're delighted to have is Lornah Afoyomungu. She's a feminist lawyer and a writer from Uganda, and she already has a Bachelor of Laws from Makerere University and a postgraduate diploma in legal practice from the Law Development Centre and a Master of Laws in Human Rights and Democratisation in Africa from the University of Pretoria. She has worked in practice as well as all this academic work. She's been a legal associate at Development Law Associates, a programme management, training and curriculum developer at the African Development Law Institute, where her role involved the conceptualisation, planning and delivering seminars in the area of international law and development. And she's currently a PhD candidate at the Centre for Human Rights at the University of Pretoria in South Africa. So the programme here is we'll have Lornah speaking, first of all, delivering her presentation, and then each of our 3 discussants and commentators will speak and raise issues to which Lornah will be able to respond. And I would encourage everybody who we're fortunate enough to have joining us today, and a very warm welcome to all of you. I would encourage you, if you've got any questions, if you can either indicate by raising your hand or during the presentations, feel free to type down in the box using the chat function and I'll come round to you at the end. So Lornah, you've got about 30 minutes or so for your presentation and I'll hand it over to you, and thank you very much indeed in advance.
Thank you, Rhona. Hi, everyone. So the proposed title for my dissertation is Post Non-Interference, and I aim to have a critical appraisal of Article 4H of the Constitutive Act of the African Union in international law. Could you please go to the next slide? Yes, so the presentation outline generally has the significance of the research, and then I'll look at the research questions that I attempt to answer, and then I'll look at a theoretical framework, talk about the gap in the literature and the argument that I raised in my study, as well as some concepts and methods, and that will be the end of it. So I'll just give a brief background before I go into the significance of the research. So the research is at proposal level. I'm working on chapter 1 currently. And basically, as the title, alludes, it's a study of the post-indifference era of the African Union. So historically, the Organization of African Union, which was the regional organization that preceded the African Union as it is now, had a history of protecting sovereignty. So the African Union, the Organization of the African Union, started in the 60s, and basically it came at a point of decolonization, and when a lot of African states were gaining independence, and so at that point it was very important normatively, but also theoretically and practically, for African states to guard jealously their sovereignty. And so at the disbandment of the Organization of African Union in 1999, and the establishment of the African Union in then 2002, saw a normative shift in approach to peace and security. And what this meant was that the foundational Charter of the African Union, which is the Constitutive Act of the African Union, then under Article 4H, which is the subject of study here, gives a right to the Union to intervene in a member state pursuant to a decision of the General Assembly in respect of grave circumstances, so war crimes, genocide, and crimes against humanity. And what formed this shift in the early 2000s was things like the genocide, the 1994 genocide in Rwanda, for instance, where African states could not intervene in what was happening in Rwanda without having Security Council authorization of the UN, and that did not happen, and that saw a demise of over 800,000 people in Rwanda. And so I come to the significance of the study and why I'm trying to study and have a critical appraisal of this article in contemporary international law. So this article, in my opinion, and various scholars agree, shows a significant normative contribution to international law by African states, but also it challenges long-standing principles of international law, like the principle of non-interference and sovereignty, and of course the peremptory norm on the use of force. But also, I think the field would benefit from a current critical study of what this provision means in light of traditional and contemporary international law. Next slide, please. So so I have 5 research questions. Question 1 being the main research questions, and then the 4 being the secondary research questions. So my first question is to answer what normative contribution Article 4H of the Constitutive Act of the African Union plays in international law. And the second one is to study the nature and history of this shift from non-interference to then non-indifference, which permits the African Union and its member states to interfere in cases of gross violations of human rights. And the third is whether Article 4H of the Constitutive Act in fact introduces a new exception to the peremptory norm on the use of force. And then the fourth is to study the extent to which Article 4H is effective in preventing mass atrocities and providing early warning systems to avert crises before they escalate. And then lastly, to study what appropriate measures can be taken for the better application of rules of use of force in international law. So then what I would say is a brief statement of the problem is that this article, like I said, seems to be a direct antithesis to the principle of non-intervention and the prohibition of the use of force under international law, and specifically Article 2.4 of the UN Charter, which requires all member states of the UN to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of states. And then also Article 53 of the UN Charter, which is also to the effect that in the instance that regional organizations, in this case the AU, are to intervene and have an enforcement action in a member state, they need the explicit prior authorization by the Security Council. But when you look at the Constitutive Act of the African Union, it is silent on whether the intervention that is permitted under Article 4H would be done with Security Council authorization, whether prior or post intervention. And so those are some of the tensions that exist between what is being developed for African Union member states, but also what is acceptable and permitted in the international plane. Next slide, please. Okay, so onto the theoretical framework. What I'm trying to put together is I'll make them three. I've looked at three theories, but I think the premise would be two. So for the critical legal theory here, I've taken out TWAIL, which is third world approaches to international law. And this particular theory, I think, is important for this study because it represents a reconceptualization of the Eurocentric foundations of international law by the AU. And so third world approaches to international law has been taken up by scholars on the continent, but also in other global south countries, to sort of have a theoretical but also a methodological school of thought that advocates for a critical reading and a reconceptualization of international law to understand its historical origins and also interrogate its imperial hegemony, and to reform this so that they can better address the concerns of developing countries, and in particular the African continent. And so, like I gave the example of the Rwandan genocide, the continent itself has been rift with coup d'etats, with conflicts, and so the situation on the African continent is different from other continents. And so if international law then is not fluid enough to sort of evolve to resolve these problems, that then see people lose their lives, then theories like I think the critical legal theory, but specifically third world approaches to international law, provide a framework within which we can envisage international law sort of evolving, but also we then get to see things like Article 4H. And so that is one theory that I wanted to base this on, but also specifically under the third world approaches to international law, I found that it would be it would benefit from having a feminist theory of international law. And here I take from the works of Judge Hillary and the work that they've done on feminist approaches to international law. But even within feminist approaches to international law, you have the third world approaches to international law missing. And so I thought it would benefit from having a feminist third world approaches to international law, which also provides still a theoretical but also a methodological approach because also feminist approaches to international law still interrogate the hierarchies and the inequalities in international law, its Eurocentrism, and how international law does not serve a specific group, which is feminist needs. And so the third world, and I feel like the feminist approaches to international law would provide a middle ground in there, a middle theory that I feel like this study would benefit from in the next chapters. And then I think this is a theory that I obviously have to look at, given that I'm looking at what the African Union has termed as humanitarian intervention. And here I'm looking at the interventionism theory. And this is quite obvious, I feel, in this study to have this, because the concept of intervention that is proposed under Article 4H is in direct contravention with interventionism theory in international law. And we know that international law, contemporary international law, is founded a lot on protection of sovereignty of states and integrity of states. And so if you're going to have an intervention, be it having a legal justification, for instance, self-defense that's envisaged under the UN Charter, or if it's an ethical or moral intervention. And here I look at a few theories under ethical justifications for intervention. I look at the arguments between the consequentialism versus deontology, in the sense of, do you look at the consequences of the results of intervention, or do you focus on adherence of the moral principles and duties of states before you intervene? And here I look at the work of Immanuel Kant, Jeremy Bentham under the interventionism theory. I also look at the just war theories, just as under this broad interventionism theory that I feel are still Eurocentric, but I'm trying to find a way to make it fit within what I'm trying to study. And so that is the theoretical framework broadly. And then next slide, please.
Yes.
Yes,
Tricia.
Okay. So lastly, I think this is the last slide. Lastly, I also, for the literature, and as I was making the decision to study this, but also to review the literature that is existing, a lot of work has been done on Article 4H of the Constitutive Act of the African Union. One, because it, like I said, it seems to introduce, or it posits to introduce a new exemption to, a jus cogens norm in international law. But what I found missing in this is its normative value and what that means for international law generally. And so I hope in the next few chapters I will make that clear. For instance, by looking at the instances where Article 4H has been evoked on the continent to intervene, where the General Assembly of the African Union has sat down to invoke Article 4H. Usually, the interventions that I've looked at have not specifically referred to Article 4H. It may have informed them theoretically, but there have been very few instances where they've been publicly invoking Article 4H, and so it's just to study that. And then secondly is, like I said, to find the middle ground between feminist approaches to international law, but also toil and to situate that squarely into the study, and it's a methodological approach that I feel like is missing in the studies that I've seen of Article 4H and its importance in international law. And then lastly, what I feel would be the tall order in this study would be on how to determine whether Article 4H could potentially prevent mass atrocities on the continent, because its formation and the normative shift was informed by the need to prevent, to be able to prevent by intervention, to be able to stop mass atrocities as they're happening. But could it also, inadvertently help to provide early warning signs? I know there's already institutionally within the African Union, there are already systems that have been put in place as early warning signs, but conflicts have still keep on happening. And so it's to study whether Article 4H could potentially be used to prevent mass atrocities on the continent, and if other continents would also be willing to adopt similar provisions in their regional instruments. Yes, I think, yeah, that's the end of my presentation.
Thank you very much indeed, Lorna. That's absolutely fascinating, and that's going to keep you very busy doing your PhD for sure. There's a lot of really interesting ideas that you have, and it's definitely an area that's ripe for quite detailed discussion. So if I could ask Noman to unshare the screen just for the commentators moving forward. And if I can start then with turning to our peer commentator, who's one of our PhD students and members of the Global South Network. So Ishoma Iweluka, can you possibly give your responses and comments in a kind of maximum of 5 minutes, please?
A really great one, and I think it's very well structured and thought through, and I really appreciate you for going into this area. It's a very important area, and particularly we all know how much Africa has had to deal with crisis and different crisis situations, humanitarian crisis. So it's a very relevant area, and the presentation was also a wonderful one, very informative, and I would like to appreciate you for that. I think the only area I'm not quite clear on, which I probably, in the course of your research, I think you would be able to be more clear in, that is the connection with Twell theory. I'm not sure, particularly as it relates to your research questions. I'm not sure how Twell will be useful in answering the research questions, and I'm hoping that in the course of your research that will become clearer. And I also think maybe in the course of your research you could also look more into like the political dynamics within the African region, and how Article 4H can be used impartially without that's in the midst of different countries and the different politics that go on amongst the countries, and just how Article 4H can be implemented without being misused. I don't know if you get the question. So I think it would be interesting to look into that, and yeah, that's really all I have for you, and I wish you all the best in your work.
Thank you very much, Ishoma. If it's okay, Lorna, since I see you're taking notes, will we just proceed with the two academic discussants, and it will give you the group of comments that you can then reflect on? Okay? Right, so if I can then turn to, we have, as we said at the beginning, two academic discussants, both with an excellent knowledge that they can draw on in responding to Lorna's presentation. So first of all, if I could turn to Joycelin, if you would like to provide your comment, you've got 5 minutes or so.
Okay.
Thank you very much indeed.
Thank you. Hello everyone. And Olum, I don't know, did I pronounce that properly? My time is running.
Yes.
I think that's an interesting topic. You know, when you were talking about Article 2, 4 of UN Charter, I was laughing because I was actually teaching that in the class today with my LLM students. So that was quite interesting. But then, what you're doing is quite important. So it's not just Africa that's having issues, you know, the entire world is in turmoil, either way you look at it, either directly or indirectly. Even though UK is not in war, but what is happening in other parts of the world is also affecting the UK. So somehow we're all, you know, involved in what is going on. And so that's why it's quite important to see whether from regional perspective or from the central perspective, we could have solutions to the world challenges we're having today. Now, quickly, I'll just say one or two things because of the time limit we've got. On TWIL, I think I kind of differ a little bit, you know, in the sense that I think it's going to be a very good theoretical framework in your, you know, to help you situate what you're, you know, doing. You are looking from the African perspective, and if you go on the general international law, it might be a bit dicey, you know, because of the African Union, you know, you're looking at. So I think TWIL will, you know, give you a very good theoretical framework to do that, because we already know that it's only the Article 4H that is where we have, you know, such you know, intervention in international law currently. So, and looking at the robust nature of Article 2, 4, and then the debates, maybe you might also have to bring in the debates around that Article 2, 4 to be able to show, you know, knowledge of what is happening. So please look at Article 2, 4 and then develop or engage with the debates around it. And then also in part of your introductory area, I think you have to lay some blocks on what TWIL is, and then look at third word, because once you're discussing TWIL, you're looking at third word, and you cannot discuss TWIL without looking at third word. Okay. I have a work on application of hegemony to customary international law, and I know, you know, a couple of scholars have referred to it to look at, you know, what third word, you know, is and how it has, you know, evolved over time. If you're interested in that, I could send it to you, because I know some scholars have made reference to that work to develop, you know, third word. So I think that's what you have to do. And then moving forward to 12 feminism, I'm not so sure how you intend to do that, but looking at 12 generally might be a very good approach. Even though 12 feminism is not so pronounced within 12, we know as at last year, they had a symposium. We also have network of 12 feminists. So these are areas you can also bring to actually engage, because if you have to do that, you have to really lay a foundation as to what that is in, especially since you're dealing with faces, so that people will understand what you're doing. And then another aspect I want to look, you know, you to also pay attention is the non-indifference. Non-indifference is also peculiar. You can see whether you can bring in the Ubuntu principle to also further explain it, to give you a strong background from the African perspective or the third world perspective you're looking at it. So look at Ubuntu principle, because that's the building blocks for non-indifference from the African perspective. So you engage with that. And then another thing I think you should look at, if the 5 minutes is not over, is your research question. I think the research question might need a little bit of tweaking. Although what you said as your introduction is a little bit different, I think I'm a little bit more comfortable. It's not about me, but I'm just saying that's just my opinion. Because I know we cannot bombard you so much, but you're still, I think from what I'm seeing, you're still at the beginning stage. So these are some of the things you have to consider, so that as you're developing, you go, you know, going forward. So look at your research question again, because then it appears, that first one appears a little bit so broad, if you look at it, because I know there are different scholars too who have tried to look at Article 4H. So see how, I know with this theoretical framework, that would help you to redefine that aspect so that it doesn't appear so broad, because people are writing from different angles. So you look at that, and then on the fifth aspect of it, of your research question, the way it's being framed, it also appears wide again. And I don't know whether that is something that is going towards your recommendation at the end of the day, instead of just coming out entirely as a sub research question. So I think that's what I would like to stop there at the moment. And then please, one more thing, sorry, before I leave. When you're looking at that humanitarian intervention, and since you're looking at from the African perspective, another thing you might have, engage with the conflicts between, there is a possibility of engaging with a conflict between African Union or regional position and the United Nations because of the Security Council. So it's an aspect we cannot avoid so long as you're dealing with humanitarian intervention. Because while some are trying to look at it from a narrow perspective, you have people who are looking at it from a wider perspective, and then there is a conflict. And so that would now make you to engage more, from the African perspective, from pre-2005 and post-2005, where at the beginning, Africa, it's fine, with United Nations Security Council, and then with ICC, what had happened over time, there is that conflict. So with 12, I think that would help you to maneuver that conflict and then come to something at the end of the day. But that's just my opinion, but you look at this. Thank you.
Thank you very much indeed for Joycelin for some very interesting and very informed comments. So thank you very much. And if I can now turn to our final, but certainly not least, our second discussant, who is Arinze. So Arinze, over to you, please.
Hello. Thank you very much again for that wonderful presentation. I think Joycelin has kind of said it all. I think we have our issues with 12. I'm not so much of a fan, but when she puts it like that, I don't have much to say. I think obviously for this research, I see a lot of value in approaching the 12 framework, right? And that said, I suppose that kind of brings an issue with, if you want to also square with feminism approaches. I think it might be too much, and there's also the possibility of that 12 probably might be sufficient, and you don't need to include feminism approaches. Again, your research is still kind of starting, so it depends on what you kind of find out going forward. I think also something you have to navigate very carefully is, especially when you say the normative value of Article 4 of the Constitutive Act. Are you trying to solve an African problem, or are you contributing to general principles of international law? You can do both, but it's you have to be kind of very mindful about that. Okay, so if the aim, and I think it's something you need to clarify a bit more, what are you actually trying to do in the PhD, right? Are you trying to solve the atrocities in Africa, or are you trying to contribute, something substantial to general international law? As I said, you can do both, but you just need to be aware of some conflicts that might come out from it. Okay, and I think it also goes to what Joycelin has also said. If the issue is, okay, you want to use this aspect of the AU Act to prevent these atrocities, then there's also some literature you have to consider in Africa. I think you need to consider, obviously, the question of supranationalism, and interconventionalism, and that question of, what do we actually practice? What does the is the AU a supranational organization? Is it just intergovernmental? Okay. I think you also need to consider the relationship between the regional treaties and the AU as well. Okay, so how do they square to each other if the AU decides to do something and ECOWAS says no, or if there is that conflict, how does it all play out? Maybe not very as important, but also the status of these laws in member states' jurisdiction. That has always been an issue with economic integration in Africa and political integration, in, even at that, right? So I think, again, if you decide that it's something you want to contribute to preventing these atrocities, then I think you obviously need to engage with these questions, okay? I think 12 is probably a good one to use, but just be aware about trying to clarify more clearly what you're actually trying to achieve, and with respect to how it's going to work, how it's good, like how to make it more effective, then definitely you need to consider the relationship between the regional and the AU and even the member states with respect to some of the things I've said. So thank you very much.
Thank you very much indeed, Arinze. Well, over to you, Lorna. You've got a lot of comments to respond to, so please just take your time.
Thank you so much, everyone, for your comments. I don't think I have a response. I was just noting down and putting it at the back of my head, and there's things that I'm going to tweak to have a full picture from all the things that everyone has said. And I also agree with Arinze. Before this, I was also not a fan of TWAIL, but I found myself having to rely on TWAIL a bit for this. And every time I meet people, they're like, TWAIL. And so, yeah, I'm just going to clarify a bit, especially the theories, but also what Dr. Joycelin said about narrowing down the questions and making them a bit less broad and more pointed and specific. So thank you so much for those.
Okay, thank you very much indeed. And looking at comments from other people, Gifty, you've got some comments. Do you want to take the floor?
Well, I've posted them in the chat.
Yeah, just
so
wondering if you wanted just to talk to it. It's just if you want to talk to it, that's all.
Oh, okay. Lorna, you've done very well. I was very impressed about how you presented. And then just as Joycelin said, I think some of the questions are a bit ambitious. So maybe you can have a look at it and then narrow it down. Given the time that you have, I think if you take up too much, it will be difficult to accomplish that. But I know you have the motivation to do it, and I wish you well. So maybe you can have a look at my comment as well, so that where necessary, you can incorporate some and then make it more robust. Thank you.
Thank you very much. Lorna, can you see the comments in the chat?
Yes, I'm reviewing the comment from Gifty. Thanks.
Yes, okay. If anybody else has any comments, please raise your hand or indicate in the chat, please, and I'll come on to you in a few minutes. Do you have anything else at the moment you want to say, Lorna?
No, but I see Riyad has his hand up.
Yep. Okay, Noman, you've got a question?
Yeah, I have. Rhona, thank you very much for the presentation. It was very interesting presentation, especially for me. I have no direct expertise on the African Union or international law, but it was so clear that somehow I was able to follow the main argument. I was just thinking about one of the slides where you mentioned 5 research questions. I was trying to understand that the research tools that you are going to use, the data collection tools and data analysis tools that you plan to use in order to answer these questions. and how are you going to justify the use of those tools as the most appropriate tools? I was just wondering if you thought about that, and if you have some preliminary ideas about those data collection tools, data analysis tools.
So thank you, Riyad. So basically, I want to do a desktop research, and so it's just going to use qualitative research methods. I'm just going to look at instruments, international law instruments, globally, regionally, so instruments of the African Union, and I've also had other regional blocks, the ECOWAS, the EAC, but also cases in international law that speak to some of these things, because some of the things have, already happened, but also to study the conflicts, and also to study the foundations of these conflicts, and, just review that and analyze that, and then have sort of my own conclusion that is put through the lens of my theoretical framework.
Okay, thank you. Anybody else with any questions? While you're thinking, if I could possibly take the liberty of adding one question. I was very interested in a lot of the paper, and indeed with the expert comments from those who know much more about this subject than me. I'm curious whether some of the discussions that you're talking about on early warning and preventing conflict, and I should say in that context that in my background I was also a UN Special Rapporteur, and therefore I worked with some of the ones who were doing the early warning, including the person who gave the early warning and everybody ignored it for Rwanda. So from that kind of background, looking at failures in the UN, Rwanda is a very good example of failure. But what I was wondering is whether some of the research on interventionist and not standing by is going to engage with the fairly controversial, I suppose, now, and possibly, given Gifty's comment as well, it's one that's been set aside internationally, the kind of responsibility to protect arguments, and whether there is actually an obligation on other countries to intervene in certain circumstances. So I wondered whether it might engage with some of that literature. And my second comment was, when you're looking at the interventionists, you said already about the challenges with the literature, that some of the theoretical concepts you're looking at are very kind of Western, European, Northern type things. And that is obviously a challenge. But I think, or I'm just wondering whether that might be mitigated or ameliorated by the fact that if you're going to use TWAIL, you've got a way that you're then challenging any of that literature. So it kind of gives you a justification if that's the literature that's normally used, and part of that can be because English language. As I said, I work a lot in Asia, so there's things in other languages there that are not UN languages. But whether or not using TWAIL might just help you, I'm just wondering, to get around the fact that some of your literature sets might be potentially not particularly TWAIL focused, but you can use TWAIL to interrogate and challenge some of those bodies of literature. So just a couple of comments.
Thanks, Rhona. Definitely, and that's why I'm bringing in TWAIL, because I feel like because I have to look at just war theory, for instance, and consequentialism, and all these are Western philosophers. And yeah, my aim with bringing TWAIL was to make it very specific, but also to interrogate some of these Eurocentric histories of international law. Like, we know international law, the way we know it, if we're not talking about African international law, is very Eurocentric. And so for me, I think TWAIL would indeed provide that. And for your first comment on the responsibility to protect, I am indeed engaging with that in the literature review, and I have looked at the way, for instance, that the UN itself has evolved, especially with, like you said, the failure in Rwanda, and how they've had this, I think it's soft law, to kind of form this responsibility to protect principle, and how that relates to the Article 4H of international law, which informed the other, the Esowini Consensus, the Pretoria Principles. And so, yes, thank you very much. I'm engaging with those in my literature, and I'll do that further. Thank you.
Okay, thank you. Has anybody else got any comments at the moment? Last chance. Oh, has somebody get a hand up? No. I'm just sorry, I'm just trying to scan the different pages. Okay, so we've got nobody else with their hands up. Just checking.
So can I just ask one question? Sorry.
Yes, please feel free.
Yeah, I'm just wondering, like, what are there like logistical challenges to implementing the Article 4H that you are aware of, in terms of is the AU equipped to be able to implement it, intervene? I'm just like wondering if you're aware of any logistical challenges that may be encountered in implementing it.
Yeah, so as far as I can tell, I had to look at the peace and security architecture of the African Union, and in order for you to intervene, you have to have, for instance, an army, and this is something that the African Union collectively, we do not have an African Union army, but under the peace and security architecture that sits at the African Union, there's a budget. And what has been happening is, for instance, Uganda sends troops to Equatorial Guinea and trains their troops. And you've also had instances of Uganda sending troops, the UPDF, to Somalia and helping with that situation there. But that's like a case-by-case basis. Collectively, though, as a region, there's no army, and it's a problem with enforcing international law generally, is it's very funding intense, and as we know, the African Union also gets its funding from the global north, and so there's those issues of funding. But policy-wise, the policies seem to be effective. It's just at the point of enforcement and implementation that we usually have a problem. But the peace and security architecture, I think, is working towards that in terms of also getting funding. But also, as we know, the African Union is a big boys club, and so usually the decision to intervene also rests upon the heads of state who make up the General Assembly in agreeing that they're actually interested in this. And so you have some, I think, like Gifty said, Libyan situations that were just hands off. And so, yeah, I think it's very subjective at that point.
Okay, thank you very much indeed. And I think we'll be drawing now to a conclusion. So thank you very much indeed, Lorna. It's certainly given a lot of people a lot of things to think about, and certainly from my background more in Asia, it's very interesting given how much the focus there is on non-intervention, particularly in the regional of Southeast Asia, which is where I often worked, and in Asia Pacific indeed. So thank you very much. It certainly highlighted a lot of key issues which are very important in the context not only of the African Union but also more broadly in international law. So thank you very much for that. I would also like to thank Isioma for her comments, and also thank you to Joycelin and Arinze, because it's very important that we do have both the peer commentators and academic commentators to contribute to the discussion and understanding of the issue. So thank you very much indeed. Good luck, Lorna, with what's going to be a very interesting period of research, but an awfully busy period with a lot of things to work through. So good luck, and I look forward to seeing how your research evolves in time. So just by way of conclusion, the Global South Network obviously welcomes PhD students from any discipline and any part of the world to share their projects and to receive interdisciplinary feedback. We happen to have a preponderance of lawyers today, but that's just random. It happens that way, as well as a preponderance of Leicester University. It doesn't always go there. It's often all over the world, and some people are sitting in early morning, not even daylight, and other people could be sitting in pitch black at night, as well as some might be in daylight. or I'm in Scotland, daylight's not often the case in winter, but never mind. So we tend to have a large combination of different people. So please feel free to join. Anyone that's interested, please just get in touch, particularly with Noman, and we will be able to hopefully include you in the future. At the chat box, you'll have a link from Noman with his email address. If not, you can contact him directly on Teams. Oh, he's done it already. Okay. If not, you can do it directly on Teams as well. And we look forward to more people joining and participating as the weeks and months go by. Next week, it's exactly the same time and the same links that you've got already for Teams. And we're going to have our next guest speaker, who's Fernando Ferro Guimarães, who is a PhD candidate also in Leicester, and will be speaking on his project, which is a critical analysis of corporate compliance programmes to prevent transnational corruption and measuring the effectiveness and proposing improvements. So that's the 22nd of January at 3 to 4 p.m. on GMT, or I should probably say Universal Central Time. So good luck with every day. I hope you have a good week, and I look forward to seeing many of you next week. And finally, thank you again to Noman and to all our discussants and commentators, and very good luck to Lorna.
Thank you very much.